Welcome to All Things ADR, the podcast. My name is Mleba Joseph Chitupila, and I am the host. Today, I have with me a seasoned practitioner who I'm excited and thrilled to introduce to you. I have with me Mr. Kaumbu Mwondela, who is a legal practitioner as his primary qualification, and he's an international arbitrator. He currently holds the rank and status of a fellow of the Chartered Institute of Arbitrators, and he currently also sits on the executive committee of the Chartered Institute of Arbitrators Zambia branch. His experience is deep. He is empaneled on various arbitral institutions such as the London Court of International Arbitration and our very own local Lusaka International Arbitration Center. Happy to have you on board, Mr. Mwondela.
Thank you very much. I am very pleased to be here, and congratulations on the podcast. We needed it.
Thank you. We were looking at very good episodes to come. Right. Today's episode is, I think, very interesting. It stems from a recent Supreme Court judgment, which is Airlink Pty Limited versus Zambia Skyways and 5 others. It is appeal number 10 of 2023. We will post a link to this judgment when we do post this video. Now, this judgment sets out the do's and don'ts, the limits, jurisdictional issues of arbitrators, and that will form the discussion with Mr. Mwondela today. Right, so having got those out of the way, we shall go straight into it. I'm sure you've had a look at the judgment. Interesting one, like I said. Maybe we'll start with one of the things that came out was what happens when an arbitrator makes a decision on an issue that was not placed before him by the parties. So maybe we can start with that. What principle does that give us in terms of the do's and don'ts and limits of an arbitrator?
Right. Thank you very much, Mleba. Perhaps in limiting, if you like, a preliminary comment is to say the Supreme Court delivered South African Airways, South African Airlink, beg your pardon, versus Zambia Skyways Limited on the 31st of December. So it's really hot off the press. And it's one of those decisions, you read it, and for me, who is a practitioner, who does litigation as well as ADR, you read it and you smile. You smile because the Supreme Court once again places Zambia right up there as one of the safe seats in terms of arbitration, because it reinforces the reality that the role of the judiciary is not to usurp or gazump the dispute resolution process when the parties have chosen arbitration as the forum for the resolution of the disputes. The Zambian judiciary will honor it. And I think that's worth mentioning. So kudos to the judiciary for that. The decision is a great one, and it discusses a number of principles. We may not have the time to get into all of them in our discussion now. As I mentioned earlier, I have written an article. I tried to go into a little bit of detail in just analyzing the decision. But coming to the points that you have raised, the Supreme Court was unequivocal and led by the Chief Justice that the principle of party autonomy in the context of arbitration is in fact sacrosanct. The parties, you see, arbitration is that dispute resolution mechanism which is different from conventional litigation, fundamentally because this principle of party autonomy, the parties are making decisions about what forum they want to resolve their dispute, what rules will apply, what procedures will apply. They even get to pick who is going to arbitrate, who is going to preside over that resolution. And they also set the boundaries of the powers, if you like, of the arbitrator. So all of those things are true of this principle that we call party autonomy. Without going into the details, basically the case, the underlying facts of the case, it is the breakdown of a commercial aviation agreement. Parties wanted to do a joint venture. It didn't work out. And they had arbitration clause in their agreements, and they took their dispute to arbitration. One of the issues that was raised by the claimant is that, so they took their matter to arbitration, and the arbitrator issued an award, right, in favor of the respondents to this particular appeal against the claimant. There were 6 respondents. Zambia, Skyways Limited, and 5 others.
Yeah.
The award went in their favor. The respondents were dissatisfied. The claimant was dissatisfied and applied to the High Court under Section 17 to set aside the award, citing various infractions. One of them is what you've raised, that the award exceeds the scope of what the parties intended. The High Court delivered its decision against the claimant. Claimant being dissatisfied, took it up to the Court of Appeal. The Court of Appeal agreed with the High Court. Okay. Finally, the claimant ascended to the final court, the Supreme Court. Hence this decision, the apex court, as it were. Hence this decision. So, as regards the scope of the arbitrator's jurisdiction, if you like, one of the key findings here is that the arbitrator did, in fact, exceed, this is what the Supreme Court said, that the arbitrator exceeded the scope of his jurisdiction by awarding damages, all right, to the 2nd, 3rd, and 4th respondents. And that this was not pleaded, right? This was not pleaded in the original proceedings before the arbitrator. Why is this important? It's important because the arbitrator must be aware. Maybe first of all, the parties to a dispute. The parties must be very clear how they settle their claim, how they settle their pleadings. Be very clear, be very specific about the things that you want from the arbitrator. And then for the arbitrator, you must treat those pleadings as the 4 corners of your jurisdiction, if you like. In an ideal world, what would happen is that you would call, now this is me with my arbitrator hat on.
Of course, and this is exactly what we want. We want the first-hand experience.
Right. Right. So ideally, when you've gone through, the preliminaries in terms of notice of arbitration, etc., you would ask the parties to submit to arbitration. And within the context of that submission to arbitration, you would also ask the parties to settle the issues. What questions are you bringing before me to settle? Right? That's ideal. So they would actually get together and agree. What is it, claimant, that you want? Respondent, do you have a counterclaim? What do you want? Then they would jointly file a submission to arbitration that contains those issues. That's the dream. The reality is that by the time parties are coming before you, their positions are so far apart that even agreeing on something as mundane as a date, because I have had that experience, where you say, can we have a preliminary meeting on this date? And it becomes a litigated issue.
Yeah.
So, because the parties are likely to submit to arbitration, if they did, those are your marching orders, as it were. That's what you're answering. But if they didn't jointly submit to arbitration, then you will discern the questions that you are answering from the pleadings.
Yeah.
So, statement of case, the claimant will tell you what they want you to answer. In the statement of defense, perhaps there might be a counterclaim. You're also understanding what the issues from that side are. So then it is your job as arbitrator to navigate through those pleadings and then say to the parties, this is my understanding of what you are asking me to decide. Then you are moving with everybody on board. So this is one of the infractions that the Supreme Court called out and said, look, this is worthy of setting aside the arbitral.
Yeah. And I'll just pause there for a bit, because one of part of our audience is the young practitioners,
yes,
especially those starting out as arbitration practitioners. And I think obviously I've now been around the block a bit in my own arbitration journey, but it's one of the principles I had to quickly learn which I now implement as I undertake my various sittings, is that, as we've said, perhaps the pleadings will give you the issues in mind, but you must always remember to be boxed in that. And I think that's, you give us more detail around that, but basically that's what the Supreme Court is saying. You're boxed in there, you can't come out. The moment you go out, then now you're in trouble, and then, like we'll discuss this further, you're then opening the door to having your arbitral award set aside. So I just thought maybe something to note for the young practitioners: always, when you have your pleadings, or maybe when they give you issues, if they're able to give you issues, you're boxed there, and then, you're moving on from there. Yeah. Right. So
perhaps just to maybe add on a little bit, again, for the benefit of the up and coming arbitrator, beg your pardon. What you are striving to do as an arbitrator, remember that parties have come before you for help, right? They have a dispute. Oftentimes, these disputes will arise perhaps in a commercial context. So they're not in the business of disputing.
Yeah.
They're in the business of doing whatever it is that they wanted to do. And then they're interrupted by a dispute. So they've come to you for help. As an arbitrator, it is important for you to keep your eye on the prize. What is the prize? To deliver an enforceable award. That's what you're striving to do. At the end of the day, you must deliver an award that settles the matters between the parties, that is enforceable, that will not be set aside. Part of what you're doing as you keep your eye on that objective is ensuring that the procedure that takes you there is sound. Because if your procedure is flawed, no matter how good your award was, your award will be exposed to being set aside. So keep those two things in mind.
Okay. Right. So do you pick up where you are, or do I?
Well, if you have another, I could go on.
Okay.
It was such a good decision.
Yeah. So, I mean, another one of the other parts that came out was where an arbitrator makes an award to a party who wasn't initially part of the proceeding. So, theoretically now, say we have A sues, A commences proceeding against B, but for some reason, the arbitrator then makes an award maybe for B, but then also pretend and say, I also give to C, So basically, we C was never part of the proceedings, but then, all of a sudden, C has a share in the award, I know that thing came out as well. It came out as part of the decision. Maybe you could just speak a little more about that and just give us context there.
Excellent. I think that perhaps let me take you back a little bit, and then I will address the issue that you've raised. We talked about procedure. Very important that you abide, again, where we began. The parties would have told you what procedures will apply to the particular arbitration, what rules will apply to the particular arbitration. You must stay with those rules. Perhaps we'll talk a little bit down the conversation about the principle of an arbitrator acting. The Latin is ex acio et bonum. All right, we can talk about that and we'll translate it. But very important, because it's touching on this aspect of coloring within the lines and staying within the rules. One of the rules is that only parties to the arbitration agreement should have benefits or burdens under arbitration proceedings, right? Only parties to it. The Supreme Court addressed itself quite squarely to this in the case of, I think it's Tiger, ZRA versus Tiger and ZDA,
yes,
if I'm not mistaken, right? And it was a public policy consideration that you can't hang liability on a party, on a non-party, on a third party who is a non-party to the arbitration agreement. Conversely, the Supreme Court in this decision talked about, I think, a Captain Mulundika,
yes,
who the arbitral tribunal had awarded damages to, and cleverly awarded damages. I think it was to the fourth respondent, if I'm not mistaken,
Yes.
awarded the damages to the fourth respondent to pay this Captain Mulundika, who was not a party, to the arbitration agreement. The Supreme Court lifted the red card, said you can't do that. Only parties to the arbitration agreement should benefit from it or suffer.
In fact, just briefly there, I hear you say red card. I would actually say the Supreme Court did the VAR and said, no. Yeah.
You're clearly a summary, aren't you?
Yeah.
VAR, there you go.
Yeah. Well, carry on.
Yes.
Yeah.
So it again for the young arbitrator, important to pay attention. What are the rules that apply to this particular set of proceedings? And to remember, because of that party autonomy principle, because parties consent to the proceedings, even consent to the authority of the arbitrator, you cannot bring a third party who didn't participate, in the arbitration agreement. You cannot bring them in. Now, of course, this raises an interesting conversation around perhaps multi-party claims. Okay, the Supreme Court in this decision made reference to Section 2(1) of the Arbitration Act, which defines parties to include non-parties who claim through parties. All right, and that's important to pay attention to. That in fact, a third party may claim. A third party who was not a party to the arbitration agreement may claim in the arbitration proceedings, but they can only do so through a party to the proceedings. Now, in this case, when you look at the pleadings, there was no third party claim made through one of the parties.
Yeah.
That's why it couldn't work. So it's an important point to remember.
Yeah. Right. And I mean, you gave us a Latin phrase there. I think it also came out in terms of one of the issues was when you have your rules, as as part of the arbitration, you say, okay, these are the rules I'm going to use, but then you then have an arbitrator who, for one or two reasons, either goes outside of the rules or applies the rules where only one party has had an opportunity to submit on those rules. Obviously, that again opens the door to having the award challenge, perhaps then successfully set aside. We could start with the Latin phrase and then.
Right.
Yeah.
Ex equio et bono.
Yeah, I don't. There are a few which I like, the easier ones, but I don't touch that. Yeah.
So basically, what that mouthful Latin expression is speaking about acting on the basis of fairness, right? On the basis of equity and on the basis of fairness, right? A related principle is the amiable compositor.
Yes.
Right? It's a related principle. Also, acting as an amicable conciliator based on equity and on fairness. Essentially, what those principles allow an arbitrator to do is it allows the arbitrator to look at all the circumstances of the case, if you like, and to make a decision that in those circumstances does justice, does fairness, does equity to the parties. So it gives the arbitrator some leverage. It has a corollary in litigation, right? So with with matters before your state court, the Constitution clothes the court with the power to apply principles of equity alongside the principles of the law. And that's where you get, coming to equity with clean hands and so on and so forth. The Constitution allows courts to do so. But because of party autonomy and consent, the parties must have clothed the arbitrator with that power to act as amiable compositor or to act ex acio et bono, right? So what the arbitrator did in this particular case, this related to claims for damages, right? So some of the respondents had claimed damages, others had not claimed damages. But the arbitrator went ahead and awarded damages to parties who had not claimed it and said that they were doing so ex acio et bono. The Supreme Court again went to the VAR and said, sorry, no, can't do. The model law, which is part of the Zambian Arbitration Act, after the amendment, the model law is read alongside, the substantive act. I believe it's at section 28, if I'm not mistaken. It empowers the arbitrator to act in this way, but only if the parties have given you that power. In this case, the parties had expressly said that strict rules of evidence would apply. Right? Strict rules of evidence would apply, which meant that the principle, he who alleges must prove, and in damages, if you are going to claim special damages, as opposed to nominal damages, you must specifically plead them and prove them. The damages, no evidence was lent to prove those damages. But acting ex acio et bonum, the arbitrator made an intelligent guess, right? An intelligent guess, and awarded damages and even awarded a figure. The Supreme Court said, now, your listeners may think, intelligent guess? It didn't come from nowhere. The case of Philip Mhango, an earlier decision, Judge Ngulube, I think it's a 1983, 81 or 83 decision. Judge acting Chief Justice Ngulube, as he then was. In fact, I wrote it down because I thought it was a useful one, perhaps that your listeners might want to pay attention to. So, in that decision of Philip Mhango versus Dorothy Ngulube and others, acting Chief Justice Ngulube, as then was, confirmed the general rule that a party claiming special loss must prove it with evidence enabling the court to determine the value of the alleged loss, and that shortcomings in proof would react against the claimant. However, and then this is where this gets interesting, he went on to state in that case that the courts have frequently been driven into making intelligent and inspired guesses as to the value of special losses on meager evidence. And this has been repeated in subsequent decisions. So this is what the arbitrator relied on, essentially saying, there are, as far as I see, doing justice and equity to all the parties would include me making an award for damages, which was not specifically pleaded, nor has it been proven, but I'm going to make an intelligent guess, in the interest of doing equity to the parties, and make an award. The Supreme Court said, can't do. The parties said, strict rules of evidence. So stick to the strict rules. If it hasn't been proven, you can't give it.
And I think that's something I've come across quite a bit. Sometimes when I do sit as arbitrator, is you find someone who say, I'm pleading, X amount, $5 million, special damages. But then when you get to the actual hearing of the proceedings, there is never that breakdown of the evidence, and yet you're saying you want strict rules, but then you're not then proving why you are saying I want $5 million, I want these special damages. And I think this judgment, gives us a bit, it reminds us, the judgment, the Philip Mhango case, I think is still stellar, still good, but it's the good reinforcement. Basically, I think us, look, you've chosen strict rules, you're saying special damages, you're saying $5 million, prove them. Go after them bit by bit. Show me why you end up with your $5 million claim also. So I think it's a good reminder as well on that. Definitely one for our listeners to keep in mind as they, craft their special damages, this type of damages, and as they choose to use strict rules.
Yes,
exactly. It's a big one.
So perhaps to just throw in the fact that even a note to counsel, right? Counsel, as you make the determination that arbitration is the forum of choice. In fact, the ideal situation is that at the point you are crafting the arbitration clause, you are thinking ahead to the dispute. And in thinking ahead to the dispute, you are thinking, will I want strict rules of evidence to apply? Or will I want the arbitrator to have the power to act as an amiable compositor, so that where there are shortcomings, it can be filled in.
Yeah. But I must say, I've always found this word intelligent guess.
It introduces some arbitrariness.
Yeah. I would, for some reason, I really believe I'd want you to, just be more specific.
Yes.
If you're claiming this, go after it, prove it to me.
Yes.
And you get it. Yeah. So that's some of the bits and pieces of it. From your reading of that judgment, is there anything else you'd want to, highlight to the audience and say, look, you need to be aware of this as you practice as an arbitrator? Maybe the Supreme Court has pointed to this do, this don't, your limits,
Right. Well, I think there's the issue. It was mentioned, not in passing, but the Supreme Court didn't spend too much time on it, but made the point. There was reference in there to a wet lease agreement.
Yes.
And the arbitrator had ruled that breaches of this wet lease agreement, which was actually a separate contract, would be subject to the arbitration and to findings within it. The Supreme Court said no. There must be a separation of these agreements, and your listeners will want to distinguish between separability in terms of the arbitration clause, right? That's a different principle. The arbitration clause will survive any defects that may be found in the main agreement, right? The arbitration clause, arbitration agreement will survive those defects. But this separation that we're talking about is where you have two or more agreements that are all related to this commercial undertaking. But those other agreements are not linked to your arbitration clause.
Yeah.
In the drafting, be careful. I've seen it in the Australian jurisdiction in the context of public-private partnership agreements, where agreements are tied. So you have multiple agreements going downstream, okay? And all of them perhaps seek recourse to an upstream arbitration agreement, right? You have to draft it very carefully, right? Because if you don't, the Supreme Court has said those agreements will be treated separately, as separate agreements. And you won't be able to make claims under these arbitration proceedings for matters that fall under a separate agreement. So that's important to pay attention to. And then perhaps a last takeaway was that the arbitrator awarded reliance damages that effectively covered negotiation and implementation costs, right? And that this was a contravention of Clause 28 of the shareholder agreement, which stated that the parties must bear their own costs. So this was about the arbitrator paying attention to the contract, right? Generally, the rule in this jurisdiction with regards to costs, if you are talking about the courtroom, the rule is that the costs are in the discretion of the court.
Yes.
That's the general rule, all right? And the default position that a court will take is that the costs will fall where they are. In other words, that party that succeeds will pick up the costs.
Yeah.
Ordinarily, that's what a court will do, right? However, what the Supreme Court is cautioning you arbitrators is pay attention to the contract. In the contract, the determination for what would happen in the event of a dispute and what would happen with the costs, it was predetermined.
Yeah.
So the arbitrator overstepped, by not paying attention to that clause.
Yeah. Okay. Yeah. So that gives us an idea of the bits and pieces that then form the bigger part of this judgment. I think, which is why I said, look, I need to get him on board for this judgment. I think it gives a lot of guidance to the do's and don'ts, limits, jurisdiction. One which, again, we'll invite our audience to then read both the judgment itself and look out for your article when it subsequently does drop off. So maybe what would be your last parting shot overall on this judgment? Last final comments on the judgment for perhaps the audience.
Well, the first thing I think I would say is what I said in my earlier comments. For me, this judgment added to a string of others that have come out from our superior courts, simply reinforce the fact that, to put it, very simply, our judiciary gets it.
Yeah.
Our judiciary gets it. There is a lot of space for ADR in this jurisdiction. And I'm broadening it beyond arbitration because, the judiciary does in fact get it. You're talking about court annexed mediation.
Yeah.
You're talking about the court will default. If there's an arbitration clause in an agreement, the court will say, stop, stay the proceedings, let's take a look at that. If it is what we think it is, it's going to arbitration. So, perhaps a side note related to that is that our jurisdiction is investor friendly. So I'm doing my bid for Zambia, but it is in fact investor friendly.
Yeah.
You can be assured that commercial agreements. I mean, this was an international commercial agreement between a South African-based company and Zambian entities, right? And the arbitral award went against the South African entity. The Supreme Court ruled in favor of the South African entity. So, again, just a level of comfort to our investing public, to our investing partners, that your investment is safe in this jurisdiction. Not only do we have the court, as exhibited in this decision, we have the Lusaka International Arbitration Center.
Precisely.
Right? Your disputes will be resolved timely in an efficient way, and your investment will be safe. So that's one takeaway. Perhaps for the up and coming arbitrator, there is no substitute to putting in the work. Is what I would say. No substitute. You have to read, colleagues.
Right. So, maybe you could give us your parting words, parting shots, especially in context of the judgment we've discussed and the do's and don'ts of the arbitrators.
Right. I would certainly hasten to say that the South African SA Airlink case reinforces the fact that, put simply, our judiciary gets it. And our judiciary is clearly pro-arbitration, and I would extend it and say pro-ADR. If you go before our courts with an arbitration clause, our courts will stop you and send you to your forum of choice. So that is a very reassuring thing. For me, the signal is clear. We are a maturing ADR jurisdiction. Zambia is a safe seat. And I would say to the investing public, come and invest. Your investments here are safe. The judiciary is mature. It is switched on. It will, if you have an arbitration clause in there, it will send you to arbitration. I would extend the conversation and say the ADR community is mature.
Yeah.
We have seasoned arbitrators. We have seasoned practitioners. We have institutions. We have the support of the Chartered Institute of Arbitrators that is training our people, excellently. We have the Lusaka International Arbitration Center, which is providing world-class arbitration services. So this is a safe seat. It can't get safer.
Yeah.
And then perhaps a word to the arbitrator. The word to the arbitrator would be keep your eye on decisions such as this, because one decision has discussed so many principles that remind us or refresh us, about how we should be positioning ourselves as arbitrators and how we will avoid getting our awards set aside.
Yeah. Okay. Thanks. I was happy to have you on board. Thanks for your time, and I'm sure we shall meet and discuss these things in detail further. And we may have you on another podcast one of these days. Thank you.
I will be very happy to come. Thank you for having me, and all the best with the podcast.
Okay.
Thank you.